Oh, they gave me the mic. And I didn't go to the day school. That's why I got this mic. Okay, good evening. This is an information session only, and we are going to be recording it. It's going to be live streamed for... It's going to be live streamed for the other people in the other communities. Come on, Jason, get with it. Okay, Nicole is here. She's going to be doing an information session or presentation. And just as a reminder that Nicole is not your lawyer for this lawsuit or class action or whatever we decided. She is the lawyer for the ban, and the council had asked her if she would do some research and provide a presentation for the community's information. So this presentation is going to be just for information only. Are you still on? Okay. Okay, we know that there's a class action lawsuit against the federal government. Okay, and one of the things that we're going to let you know is that the school records here, they don't have your records for anything, so that they're going to be, I don't know how they're going to be found, but Nicole is going to explain that process to you and how we can get those records for validation of what years you went to school, etc. We understand that, you may all have some concerns, and some of them may be serious, and there may be other, issues that you want to discuss, but tonight is not the time to discuss this. This is just like to get some clarification for some information only. So you will have an awful lot of time. There are some lawyers that are representing your case, and Nicole is going to provide you some information on applications, some handouts, but other than that, we're not going to be able to answer any questions for you because of the recording and the live stream, or it wouldn't be fair to the others watching it. Okay, Nicole.
Okay, thank you very much. Thank you, Sharon, and thank you to Chief and Council for having me here. Thank you, everyone, for showing up. We don't have food. We'll get food next time. I just stayed. I had a really good supper. I'm going to give you a presentation, and I'm not the lawyer that's been working on this, and I can only tell you what I know based on this. These are documents that were filed by the law firm that's working for the plaintiffs, so the class, the class means all of the people who are eligible to be registered as a plaintiff in the class action, okay? So if you attended the PIC day school, or if you attended another federal day school, you would be eligible to be a class member. Now, your lawyer, the lawyer representing this action, is a law firm called Gowlings out of Ottawa. They have offices in Toronto. I think they have offices in Hamilton. They're a national law firm. I do have a few questions about what Gowlings is proposing to do and what this settlement agreement proposes to do, and whether or not, in my view, people are supported appropriately through what I see in here. This settlement agreement is going to a hearing in Winnipeg on May 3rd, 13th, 14th, and 15th. So I'll talk to you a little bit about that process. I have forms here if you want to opt out of the settlement. If there are 10,000 people or more who opt out of the settlement would have to be revisited. I doubt that the settlement would be rescinded by Canada, but maybe it would have to be revisited. And then I also have forms here if you want to opt in. So if you decide that, yeah, I'm happy with all of this, we can go ahead with it. So we have those two forms. So Jason, next slide, please. So I'm not your lawyer. I work for the First Nation. This presentation is being recorded and live streamed. So a few weeks ago, we were in Thunder Bay. The Lands and Resources Department was doing a presentation about the Lands and Resources Department. And there were members who were off reserve there who said, gee, it would be great to see this presentation. So, thank you to Debbie and to Jason for making that happen. We're asking that you don't ask any questions, especially of a very personal nature during this part of the presentation, because it's so public. This is going to be posted on YouTube, so please keep your private questions private. I'm happy to talk to you privately. I'm not your lawyer in this action, but I can tell you generally I did, like 6 years of personal injury law, so I have a pretty good basis in this area of law. And we want to keep this as a safe space for everyone. Some of the things, next slide, Jason. Some of the things that we're going to be talking about are a little bit traumatizing. So when I go over the ways that people are going to be compensated for the levels of harm, some of the things that I'm going to say to you are a little bit difficult to talk about and to name, and they might bring up triggering memories for people. And I don't know the full extent of what people's experiences are here. But we just want to let people know that community supports are available. You have a strong mental health and a community health group here, so please use those. Talk to your family doctor. Your records will be everything. If you want to prove that you've suffered very difficult things, your records are important. So make sure that you're talking to your doctors or to your counselors or whoever about the things that you are dealing with throughout this process. All right, so just as by way of overview, this is a settlement that has been reached between Canada and a group of individuals. So it's called the McLean Action. You guys have probably seen that. Gary McLean was the representative plaintiff. He died recently. And then there are a number of other plaintiffs. So there's been a settlement agreement that's been reached between the minister, I don't know what she's the minister of, Carolyn Bennett. Her ministry now is Indigenous Services, yeah. Or no, relationships. She's the relationship lady. So Carolyn Bennett, you know that there was an apology that was issued about what happened in the residential schools. So in this case, the lawyers for the plaintiffs said, look, you've already apologized for what happened in the residential schools. We think that covers all of the harms that have happened in the day schools. So we think that you've already admitted that these things have happened. So we're starting this claim on that basis. Roy, we're trying not to take questions during the live stream, but yes? So this package is available online. I'm going to go through I'm going to talk about the overview, and then the lawyer who's handling this file has a very long form presentation. Maybe we can hand this out now. Kim, Sharon. This is the information that the lawyer for the class has provided about the settlement. So we'll go over this as part of the settlement. Thank you for that question. So in the settlement, the proposed settlement, which has been reached by the lawyers for the plaintiffs, so the class, and Canada, it provides for a huge amount of money as a settlement, billions of dollars. And what that equals to, it's like 147 billion. And what that equals is individuals can make claims based on the level of harm that they've experienced or gone through, and we'll go through what those levels are. And the values of the claim are between 10,000 and 200,000. Okay? So that's the overview. We'll talk about what that means in more detail. And then there's also a family class settlement, which is worth $200 million. What that is part of the claim, and I'll go over some of what's in the statement of claim with you. Part of the claim has to do with loss of language, being interrupted from your family, parenting issues, cultural loss, language loss, etc. All of those things that are essential to why First Nations people should run their own education system. So the things that Lisa and her team are managing here in Bigiktigong, making sure that people are out on the land, that you're attached to your culture. The basis of this claim is that because the Department of Indian Affairs ran the day school in the way that they did, it created separation. It prevented you from having that good cultural knowledge. And in fact, I think what I've heard from a lot of people in just the short period of time is that through the day school class action, people were actually made to feel less than for being Indian, right? You were told that, I don't know what you were told, but some of the stories that I've been told is that it really actually was trying to make Indigenous kids just ordinary white kids. Or, I don't know if there's such a term as ordinary white kids, but that's the pleading. So there's a $200,000 family class settlement that's going to be available, and that's going to be project-based funding for things like land-based activities, language-based activities, and that will be dealt with separately, but that has to be an established organization that makes that application. So that's the overview. Next. All right, so I've given you guys this notice of certification and hearing for approval of settlement. I want to give you guys this as information. This has been prepared by the lawyer for this file, Gowlings. What I'm going to propose to do is we'll go over the class action presentation first, and then maybe we'll look at this in detail and we'll see if there are any questions arising out of the presentation. Is that okay? So you'll have this. You can take this home. You don't have to take notes tonight. This is the long form. There's also a short form if you guys want to see the short form, but this is the long form that gives all of the information that we know to date. Okay? There's a confirmation hearing May 15th. I think it's actually May 13th to 17th. I think I have those dates wrong. Where's Dana? 14th, 15th, 16th in Winnipeg. So if you guys, if anyone here decided to object, they could do that. So the objection form, right? Red means no, green means go, okay? In my review, and I'll go over this with you, I think there are still a lot of unanswered questions and things that we don't know. And I think that could be a function of there's a huge class. There are approximately 127,000, approximately, this is what Gowling's material says, 127,000 people who are affected, who are eligible to be claimants. So it's a huge number. And there are approximately 700 schools that were registered as day schools. So it's a huge project to launch this class, also to support individual people through the process. So I have a lot of questions in just reviewing this about how is this going to unfold? How are people going to be supported? How do we make sure that people, you guys are all here tonight, but you can probably each think of 5 of your cousins or family who are in different situations than you that aren't here, right? Who would need a lot more support to go through this process. So I have unanswered questions, and we'll go through that as well. Okay, so students who are suffering harm while attending the school will be eligible to a minimum of $10,000, provided that you meet certain criteria, and we'll go over that. It's a pretty low-level criteria. The students who experienced physical and sexual abuse are eligible for additional compensation with amounts ranging between $50,000 and $200,000. This is a pretty big range. It's a significant range, actually. And the jumping point between $10,000 and $50,000, I mean, that's a huge difference, right? And what do you need to prove that is pretty significant. And that's why I think First Nations people need support on the ground to support these claims. Next, yeah. So the overview of the claim is that Canada created, designed, established, funded, operated, supervised, controlled, maintained, and regulated Indian day schools. So actually, pursuant to the Indian Act, I didn't include this in my presentation, but if anyone's interested, I have a really long presentation about what the Indian Act did. It was actually illegal for people to not go to day schools. You were forced to go. Under the Indian Act, you had to mandatorily go to school. If you didn't go to school, there was a truancy officer that could come to your house to force you to go to school. The truancy officer was normally the Indian agent, and if your parents didn't send you to school, it was a punishable offense. They could be sent to jail. So it's very significant. And there are provisions similar to this under the Education Act, not as strict, but those provisions about the truancy officer and your parents going to jail were only repealed, so only taken out of the Indian Act within the last 10 years. So this is a long colonial legacy that we're dealing with, okay? This is why this is important. So the purpose of these schools was to strip students of their Aboriginal culture and identity and removing from them, as when they became adults, their ability to pass on to succeeding generations their spiritual, culture, and linguistic heritage. So that's the basis of the claim. Do you guys understand that the schools are designed to interrupt your ability to be an Anishinaabe person? Language, culture, heritage. So here's a very long legal quote, but I'm going to show it to you anyways. This is the basis of the claim. By implementing the assimilation of Aboriginal children into the culture of Canada, Canada has breached its duties to the plaintiffs and to the class members. Canada directly and by way of vicarious liability breached duties of care owed to plaintiffs and class members in negligence, fiduciary obligations, and Aboriginal rights. Canada set out to cause damage for which relief is claimed by intentionally breaking the link of plaintiffs and class members to their culture and identity. So this is the basis of the claim. So vicarious liability means that when I hire employees, so Canada was the employer and they hired a series of employees, the teachers, the principal. By doing that, even if they weren't directly supervising these employees, so Canada, it's not like Canada came every day and watched what the teachers were doing. The principle of vicarious liability says that they're still responsible for what these activities did, for what these teachers and these employees did. So that's why we have Canada available as a defendant and therefore available to pay for the cost of this. Does that make sense? Lots of lawyer language in here. So negligence means that you have a duty of care. So the teacher has a duty of care to the student, and that you've breached the duty of care by falling below the level of the reasonable teacher. So the education that you guys received, the care that you guys received within the school fell below the standard of the reasonable teacher at that time. That's the allegation. The fiduciary obligation, you guys know what fiduciary means. It means that Canada has a special discretion over its relationship with Indian people, with Indigenous people, and the Crown has often exercised discretion against the best interests of First Nation people. We see fiduciary duty in a lot of litigation involving Aboriginal and treaty rights. And the intentionality, I think, is what brings this claim to the level that it's at, is that the whole purpose of the Indian Act is to remove the Indian from the child, right? And we see lots of quotes that support what the motive of that of that legislation is. Next, Jason. So the claim says that Indian day schools were designed and operated to create an atmosphere of brutality and intimidation. And I've heard a little bit about that from you guys. I think it's important that you tell your stories. We're just not doing that tonight in this forum, okay? So I want to apologize in advance, but it is important that you guys get supports and that you begin the process of remembering what that looked like, so to have safe people to talk about that with. And then the allegation is that the Crown knew or ought to have known that that would result in the systemic infliction of severe physical, mental, and sexual abuses in students attending Indian day schools. So we'll go to the next slide. I want to show you, so in this material there's a copy of the statement of claim. And when you draft a statement of claim, you have to say who the parties are, and then you have to say the factual history, you have to say what happened, and then you have to say what damages that caused. So in this case, the lawyers worked with the representative plaintiffs. They would have went out and talked to other people, and here are the list of things that are claimed in the statement of claim. And I know this is troubling, right? Like, this is a lot to take in. So just try not to take this personally, although I know these are very personal experiences. So the plaintiffs have sustained damages including assault and battery, sexual abuse, severe emotional, psychological pain and suffering, loss of language, culture, spirituality, and Aboriginal identity, isolation from their family, community, and nation, an impairment of mental and emotional health, in some cases amounting to a permanent disability, so people might still be in counseling for these things, an impaired ability to trust other people or have intimate relationships, or the ability to control anger, an impaired ability to control anger, a propensity to addiction, alienation from community, family, spouses, and children. There's a huge list here: depression, anxiety, emotional dysfunction, sexual dysfunction, deprivation of an education, loss of self-esteem. Like, this is all really depressing stuff, right? And this is what happened because of the day school and the way that the federal government managed it. So these are the allegations. And Canada says, look, maybe we can't defend this and maybe we need to settle. So it's a recognition of what happened was bad. So it's a validation for these things that people are suffering or experiencing in their lives. And they say, okay, here's an important material contribution or cause to the things that you experience in your everyday life. The federal government is saying, look, we know that the day schools were bad and contributed to that, or caused that, or direct cause that. Who knows all of the factors, right, that affect people. So it's a big, long list. If you want to look at this statement of claim, it's here. And if you want to look at this list of factors, it's here. Nightmares, flashbacks, sleeping problems, fear, humiliation, embarrassment, impaired ability to express emotions, loss of ability to participate in cultural practices, etc., etc. It's a big, long list. And I think this list is important for you all, too, when you start to reflect on we're not at the application process yet, but when you start to think about how these schools have impacted you, that would be a helpful list for you to look back on and think about the damages that you've suffered. Okay, the survivor class are people who attended the Indian day school in Canada during the class period. So I'll show you a list of schools in the region, but what's interesting in Pick River is that the day school actually didn't Pick River took over effective control in 1997. So people are eligible if you attended school up until 1997. It's a pretty big window. We did the math. It's people who are 26 years of age or older, or people who were born in 1993 or before. It's a huge group of people. So Pick River is unusual. Long Lac has a pretty similar time frame, but most of these day schools in First Nations, I'll show you the list, but they were only like maybe 10 years and they closed in 1960 or 1950. So it's really interesting to see this is a really unique community from that point of view. So you guys who attended, you were the survivor class. The people who didn't attend but who are impacted, so my mom went. I'm a family class because I am a spouse, former spouse, child, grandchild, or sibling of a survivor class. So the class period goes from January 1st, 1920 to the date of closure of the Indian Day School. We'll go to the next slide. Okay, so local schools, Pick Day School, aka Pick Heron Bay School. And this, I actually brought another copy, but the list of schools, if anyone is interested, I think there are something like 700 schools, is in this material if you want to see them. There's like a big chart, lots of schools, lots of schools. Some places like at Six Nations had like 13 schools. So Pick River had one. Okay, Pick Day School, aka Pick Heron, established June 1st, 1927. So there was a predecessor. So there was one school that was run from June 1st, 1927 to September 1928. And then the second school would have ran from that point to April 1997. So that's, if you were in school at Pick Day School as of April 1997, you're considered a class member. Okay, that's the time window we're dealing with here. Mobert established November 18th, 1929. Transfer closing date March 1981. McDermott, Rocky Bay, established 1951. Transfer closing date 1961. See, that's an example of only a 10-year period. Next, please. Long Lac, established November 1st, 1945. Closed 1971 to 1972. Lake Helen, 1881 to 1967, Roman Catholic. See, most of the schools in the district were Roman Catholic, with the exception of Hornepayne. Michipicoten Harbor, 1882 to 1948. Hornepayne, 1951 to 1962. Anglican, that's the only one that's actually not Roman Catholic. Next, please. Aroland, 1949 to 1974, Roman Catholic. Mission Bay, aka Squaw Bay, 1920 to 1968. Pays Platte had a school from 1950 to 1954, Roman Catholic. Next. White Sand, 1930 to 1941. Gull Bay is the one that was a recent closing. It wasn't Long Lac. Gull Bay established August 1st, 1915, closed 1995. And McIntyre Bay, aka Sandpoint, 1920 to 1942. So do you see how interesting and how impacted this group is as compared to other First Nations? Okay, now I'm going to go through some of this stuff, and this is pretty sensitive language. It's pretty sensitive in terms of what happened to people. It's awful. In fact, it's really gross and really terrible. But I'm going to go through this. Some of this stuff is troubling, so I apologize in advance. So the lowest level compensation is $10,000. The highest level is $200,000. Jason? So level 1, this is a pretty low threshold to get to the $10,000. So what you have to do is you have to establish that you have suffered from verbal abuse. And these could be all sorts of things, including mocking, denigration, or humiliation by reason of Aboriginal identity or culture. So you can think about what that means, how to be teased about being a First Nation person, being mocked, being felt like you were made to be less than. It's a low threshold to get into. I'm not saying it's not better or worse in terms of the harm, but to get into this category, I don't know, I can't prejudge what your experiences are, but this is designed to be accessible to everybody. Threats of violence or intimidating statements or sexual comments or provocations. The next, please. Or you will have suffered physical abuse, including but not limited to unreasonable or disproportionate acts of discipline or punishment. All right, so corporal punishment, spanking, any unreasonable use of force against children. Now, in order to access this level, so this whole claims process is designed so that people don't have to go for interviews, they don't have to go for hearings, they don't need to be cross-examined. It's a paper-based application. So I can show you a draft copy of the application form. It hasn't been approved yet, and in fact, I think it's too vague at this point. But in order to establish this at this time, you have to have your given name, your date of birth, your home community, the name of the school you attended, and then a witnessed declaration. So what you have to do is you have to write down what happened to you that brings you into this category. And that's going to be witnessed, and you're going to declare. So you know when you're signing an affidavit and someone says, do you swear this is true? And you say yes, it's going to be a declaration, so you don't need to actually swear to God, but you declare it to be truthful, and then someone is going to witness you making that declaration. So the whole purpose of this is that you're presumed to be truthful, okay? No hearings, no cross-examination, at this level, no witnesses. You just have to tell your story for level 1, okay? Level 2, so This jumps up considerably, right? Like the difference between 10,000 and 50,000 is, in my view, significant. So at level 2, here you have to prove, or you have to have a declaration saying that you believe that you suffered these things. Physical assault causing serious but temporary injury requiring bed rest or infirmary stay. So you're sent to hospital or you're sent to a nursing station. Loss of consciousness or broken bones. Next. And then any of the following. Touching with a sexual purpose or intention, including touching with an object. The act of an adult exposing themselves. One or more incidents of fondling or kissing, or nude photographs taken of the claimant. Now, I don't know, based on this, whether that also includes student-on-student harms. So, incidents of fondling or kissing. I don't know, based on this, whether that includes, you know, an older student or a younger student or something that you didn't consent to at that time. This material is not clear. So that's a question mark. In order to do this, you would have to show all of the things that I mentioned before. So your given name, date of birth, home community, name of school, years at school. And then you would also have to have school records such as report cards or enrollment forms. So that's where the OSRs would become, you know, your supplementary proof. We're not actually sure, Lisa and I had a call with Debbie about this, we're not actually sure how much relevant information is going to be included in your OSR. It might be helpful, and we might do this yet, to get a list of, from the federal government, all of the people that did attend the Pick Day school, because I think that would help people during their remembering. We haven't done that yet, but we would be available to access that through a Freedom of Information request. So contemporaneous school records. Now, to prove level 2, in addition to those other things, you will have to also have a narrative of specific events giving rise to the claims. So you'd have to name the person that did it to you. So you'd have to reach back into your memory and figure out the name of that teacher or the person. And supporting information by way of family or friend narratives. So we're going to assume that back then you told someone, or you've told someone when you were an adult. And also photographs, diaries, reporting on incidents. So if you kept a diary as a kid and you still have access to it, I mean, that's a long time ago, right? Who I don't know who still has that. Or if you went to get seen by a doctor. So if you had a broken bone and you went to get seen by Dr. I don't know, Govan in 1980, the Marathon Wilson Memorial General would have access to those records. And then you would also have to make your declaration, the same as the other level 1. Is this making sense so far? Okay. Level 3, we'll go to the next slide. So the numbers are going up significantly, right? And based on, I just wanted to say one thing, based on the amount of money that Canada has given for the survivor class as a settlement, based on the estimated number of 127,000 survivors still existing, the numbers equal, the average available to each claimant is $100,000. But I don't know how many people suffered at this level. It's pretty significant. So this would be isolated physical assaults leading to permanent or demonstrated long-term injury, impairment, or disfigurement. So if you broke an arm, for example, and it didn't heal properly, and you had a disfigured, or maybe if you had a scar, or if you're still in counseling, that would be arguably a permanent disfigurement or a permanent impairment. Or isolated incidents of any of the following acts: masturbation, oral intercourse, or attempted vaginal or anal intercourse. And I do apologize for this is tricky to talk about. This is very difficult things that people went through. This is the same validation criteria it's the same as level 2. It is the same as level 3. So it's important to have the narrative of what happened to you and the name of the person who did it to you, and then anything that you have surrounding the event that you could use to prove. So diaries, medical records, etc., etc. Okay, level 4, 150,000. Repeated and persistent physical assaults leading to permanent or demonstrated long-term injury, impairments, or disfigurement. Isolated incidents of digital, anal, or vaginal penetration. Anal or vaginal intercourse, or anal or vaginal penetration with an object. Okay. Level 5, 200,000. This is the highest level. And there's a real big emphasis here on sexual abuse being the worst type of abuse, according to this settlement framework. Repeated and persistent incidents of oral intercourse, masturbation, digital, anal, or vaginal penetration, anal or vaginal intercourse, or anal or vaginal penetration with an object. All very terrible things to have to go through at a day school. Also, isolated physical assaults leading to permanent or demonstrated long-term injury, impairment, or disfigurement. So this is the physical piece, but if it also happened alongside sexual abuse, that brings you also into the $200,000 category. Okay? I don't have any more information about what this stuff means. I'm assuming we'll get more information about the precise how to prove these things, and you're presumed to be truthful, okay? So that's the difference with this proposal. You're presumed to be truthful, but the point is, when you prepare your material, we'll go to the next slide. You make your claim in writing only. No hearings, examination, witness testimony, etc. You have to choose, so you decide to self-select. So I fill out my form and I say, gee, I think what happened to me was at a level 2. So what happens is there is a claims administrator. The claims administrator is going to take a look at all of your material, all of your supporting documentation, and the claims administrator is either going to say, yes, I approve your claim at your proposed level, or no, I think you're one level too high, so I'm going to bump you down a level. Or they can actually decide to bump you up a level and send it back to you to ask for more information. The claims administrator is going to have a lot of power and discretion over the decision of these claims. I don't know who this claims administrator is going to be. All it says in the material is that it's going to be mutually acceptable to both the plaintiffs and to Canada. So it's a big job for someone, some firm, some person. So the declaration piece, again, people are presumed to be truthful. Next, Jason. So this is what I was saying. The claims administrator, once they review your material, they can send you one of 3 letters. They say, yes, you're eligible as a class member. No, you're not eligible. Or we need additional information to determine your eligibility. So that's at the initial stage. Next. So in terms of the assessment, the claims administrator, I've already gone over this, but I'll say it again. They review the claims to see whether the claim meets, does not meet, or exceeds the requirement of the level. So you choose your level. Someone looks over it and says, yes, no, maybe. And then you'll get a letter saying, yes, you're at the level, you're below, or you're above. And then if you don't agree with what the administrator says, there is, pursuant to this process, this proposed process, reconsideration that would be available. Next, Jason. Now, here's where I'm confused a little bit by the material. I don't know, so there's a series of lawyers from this law firm called Gowlings. They're the class counsel. This claim was started in 1997. Gowlings took over only a year ago, or 2 years ago, I think in 2018 or 17. I don't know the level of support that Gowlings is providing. So I don't know. I know that Gowlings, the lawyer who's running this file, his name is Robert. He's a former lawyer for Canada, so he's worked his whole life at the Department of Justice, Canada, who incidentally is on the other side of this now. So he's gone from working for Canada to now suing Canada and negotiating this resolution on behalf of day claimants. So this is interesting to me. And also the proposed legal fee that Gowlings is being granted pursuant to the settlement agreement is $55 million. $55 million is the equivalent of 150 lawyers billing at $500 an hour for full days for a whole year. It's a lot of money, right? It's a lot more money than... Anyway, I don't understand in these materials what supports Gowling is providing to you at this stage. I know there's been an offer to come out and give presentations, so that's available. The lawyer says he'll come if he's invited by the First Nation to come, so that's available if you guys want to hear from Gowlings. I think it's a difficult process. Like, even reading this stuff out loud is difficult. I think putting this to someone to say, now tell me all about your life and write this in this form and figure this out, I think is tricky, right? I think people would need a lot of support. We'll go to the next slide, Jason. I'm not sorry about that. I'm not totally sure what supports are being proposed to offer by Gowlings. Not sure at this point. Now, we know that all of you guys are here, so it's great that you're here. My other question is, what about the other people that aren't on the internet? Maybe they don't have TV, maybe they're on the streets, maybe they're in hospitals, maybe they don't have mental capacity, maybe they don't have family supports. How are we going to reach out, or how is Gowlings, this is actually not my file, Gowlings going to reach out to those people? I think also, in order to really support people through this process, because the numbers are so different, right? 10,000 to 50,000 to 100,000. You want to make sure that you're telling your story in a really good way that's supported in a meaningful way to get you the support, like financial support that you need. So I don't know at this point. It's unclear from the material what supports are available. Identify, interview, support. I know people are hospitalized, some people are in jail, and lots of people are in jail. Indigenous people are the most highly overrepresented population in jails. Some people are homeless, they have no fixed address. I think these are all issues that need to be addressed. Also, people who died, this is what's interesting about this file too. People who died November 2007 or later, their estate would be eligible to make an application. So you can go through your mind and you can think about all the people who have died in the last 12 years. They would be eligible to make a claim as well. Now, I'm going to also tell you, for those of you who don't have a will, I'm also doing an estate planning session, information session tomorrow, where we're going to talk about the importance of having a will. It's also important for this process, because if something happens to you while your claim is being, administered or thought about or considered, you want to protect your entitlement to this settlement. And I would recommend that each of you start to think about getting your wills done on an ASAP basis, because this is really important. Now, the thing about Indian wills is they have to be they have to be approved by the Minister of Indian Affairs before they're considered to be valid. So we would need to start to get that process rolling ASAP. So for people who died between now and November 2007, who died without a will, there are provisions under the Indian Act that says what would happen. But I don't really think this is spelt out very well. I think this is another big question mark that we're going to have to wait and see. But for you guys, I would recommend thinking about getting support to write your wills. Next. Okay. Questions that I have. Not sure about how Gowlings is going to work with claimants without re-traumatizing them. Also, I think there's a reliance on the wraparound supports that the First Nation is providing. So I wonder what Gowlings plans to do if you're gonna, have the day where you bring people in to write their statements. I don't know what this looks like yet, but are there gonna be services and supports? Because I think that's pretty traumatizing to talk about these most vulnerable and difficult things that happened to you when you were your most vulnerable and innocent, right? A kid. And I'm not also sure about how First Nation governments, so like Pick River First Nation, will be involved in the process, or Pick River Health. Will you guys just get a call and say, okay, we need your support on these days? And also, if Pick River decides, or other First Nations decides, to bring in their lawyers because they think that the individuals are not being supported well enough through this process, is that something that we can send a bill to Gowlings to say, look, our people need help and you're not helping them? Don't know, it's a question mark. And I'm not trying to be adversarial, but I'm trying to look out for the best interests of you guys and people who are more vulnerable than you guys, right? It's a pretty wide range of people who are impacted. Next, please. So here's what they do tell us. The lead lawyer is a former Department of Justice lawyer. I think that's interesting. Culturally sensitive legal services is really important. Being able to have a relationship with people and talk about things in a way that people understand and feel comfortable is important. So the proposed settlement agreement says that Gowlings is responsible for communicating with you guys, so sending out notices. So Dana tells me that she gets faxes sometimes from Gowlings. Dana also tells me that sometimes you guys come, or you guys or people come in and they get forms. So that's what Gowlings is doing. There's also a public relations firm that's being hired, so they're going to put out notices on digital and social media, maybe on APTN or who knows, to give more information about this process. Gowlings is being paid $55 million for their work, and they're eligible for a $7 million bonus after the claim is finalized for additional work they might have to do. So it's a pretty big paycheck. Okay, next. Understatement of the year, right? That's a lot of money. That's a lot of money for the services that are being proposed. I think that's a big question mark. If I was going to Winnipeg, that would be my biggest question mark. And I know that people are going to challenge the issue of First Nations people, claimants, being entitled to have their own legal supports through the process. Even though this is just an application form, I think this is one of the most significant application forms you'll ever have to fill out in your life, right? Like you should have support through that. So the hearing is taking place May 13th to 15th. I got the date right on that part of my presentation. Claimants, you guys, I have forms. Green means yes, I'm cool with this. Red means I want to opt out. If there are 10,000 or more people who decide to opt out, the settlement has to be revisited. I guess it's scary because you say, well, what if Canada withdraws? But I think it would actually mean Canada has to revisit how this is going to be rolled out, because I think there are still a lot of questions. If you decide, you don't have to fill out forms tonight. If you decide that you do want to either file a notice of objection or you agree with the settlement, you would have to postmark those by May the 3rd. You don't have to do that. But I brought the copies of the forms if you want to do that. And we also have copies here for those of you who haven't filled out this original registration form. So you haven't registered to be a member of the class yet. You can do that. We have these forms available. This is not the application form to talk about the level of the harm. This is just to get your name on the mailing list so that you're part of this class now. Okay, so you're impacted by this. Next, please. I think that's it. Final thoughts. Still lots of unanswered questions about the process. We're going to end our live stream now. We'll have a short question and answer period. I cannot purport to answer as your lawyer. I can just purport to answer based on this. I can write down people's questions, though, if